Okay, well, it's 2 o'clock, so let's get started. Thank you for joining. I'm Michael Ettinger from Ettinger Law Firm, and this is our Zoomside chat. I think it's the fifth in a series of six. And today we're going to do 10 reasons why you want an elder law estate plan. Our website, you can see, is trustlaw.com. There I am in the top in the middle of your screen. To my left is my lovely wife and law partner, Suzanne Ettinger, a number of other attorneys and support staff. Ettinger Law Firm's practice for 35 years, this is our 35th anniversary, is limited to trusts and estates, wills and probate, estate tax saving strategies, Medicaid trusts, and Medicaid applications. We have two offices in Nassau County, Rockville Center, where I happen to be today, and Lake Success. In Suffolk, we have three offices. We're in Huntington Village itself, across the street from Besitos. People know that. We're in One Huntington Quadrangle in Melville, and we're over in Islandia at 377 Motor Parkway. Staten Island, we're at 900 South Avenue, one of the Nicotra buildings. Westchester, in near the courts, 140 Grand Street in downtown White Plains. Rockland, 345 Main Street, also down the street from the courthouse in New City. Orange County, we're at Crystal Run, and next to the police barracks there in Middletown. Dutchess, two offices, Fishkill, and in Rhinebeck, and in Albany right there on Wolf Road. I've been there for 35 years. So with that, let's get started. You can post, some people sent questions ahead of time. I'm going to hold those to the end, and we'll answer those at the end. And then if you have questions, you can type them at the bottom, and we'll answer all your questions at the end as well. So let's get started. So reason number one, this is the countdown, right? Reason number one, we should really do reason number 10 and then count down to number one, a little more exciting, but we'll do 1 to 10. So the number one reason is to control who it goes to. So, if you don't have a plan, the state says who gets which assets. If you have a spouse and children, it's quite a mess. It gets divided up. If the children are minors, all kinds of bad things happen. If you're leaving things to grandchildren, same thing. If they're minors, the state gets involved. They appoint a lawyer for them. The lawyer acts as a guardian until they're 18 and turns it over because 18 is the age of majority. And it's not a happy situation because generally an 18-year-old is not very good at handling money. So this way, it's going to go to who you want. Well, obviously, you don't want the state to decide who it goes to, but it's going to go when you want. So typically, in an Ettinger Trust, when we started out in 1990, quite a while ago, we said the kids get it when they turn age 25. And that seemed reasonable at the time. We're talking 35 years ago. Over time, we learned from experience that 25 was too young, so we raised it to 30. That went for a number of years, and today we use the age 35. Now, I'm not an expert on this, but my opinion, anecdotally, is that as the life expectancies are increasing dramatically these days, it seems that people are maturing more slowly. If you live to 50, you better be mature by 20 or you're in trouble. But if you live to 100, well, you can take your time. 30, 35, still young. So we find there's no really downside to leaving it in trust till they're 35. The trustee can use the money for their health, education, maintenance, and support. Whatever they don't spend on them, they turn over at age 35. If they're not ready, the trust allows the trustee to hold it back for various reasons. But it's going to go to whom you want, when you want. Now, if it's a lot of money, you might pay it out, for example, 20% when they're 35, half of what's left at 40, the rest at 45. The theory there is they get to 20%, they blow it, but they have to wait 5 years before they get the next half. And finally, 10 years later, and have some smarts, half the estate is still protected. So it's going to go when you want. And it's going to go the way you want, which I just mentioned. And, it doesn't necessarily have to be equal. What if you have um, one son who's, say, a hedge fund manager and a daughter who's a massage therapist? Do we have to treat them the same? Well, in estate planning, we have an expression. We say, there's nothing so unequal as the equal treatment of unequals. I'll repeat that. There's nothing so unequal as the equal treatment of unequals. So how do you deal with that? Well, we recommend the use of something called the soft probe. Sometimes the one with all the money still wants their share. So you go to your son and say, we're planning our estate. We're meeting with our estate planning lawyer. And, we know you're so much better off than your sister. We're thinking maybe leaving her more or the whole thing. And you elicit a reaction from him. It's called the soft probe. And he'll say, well, I don't think that's fair. I think I should get my share. Or he'll say, I don't need it. Leave everything to Mary. I'll be perfectly happy with that. So the soft probe goes a long way to making sure your son and daughter will get along after you're gone. So that's one way to do it. Um, so estate planning is about getting the money to whom you want, when you want, the way you want, with the least amount of taxes and legal fees possible. Reason number two is giving back, or another way of saying it, paying it forward. You went to this illustrious looking college here, and they gave you a great education, your professors, the way they ran the place, your peers, the values you got. And you want to do something for your alma mater. I've given generously to my law school because they were I was very well trained. They were very dedicated. Um, and I feel that I've reaped the benefits of the quality of the education I've had. And so I feel good about helping future law students, helping the law school. I sponsor the business chair, and that's very rewarding for me. Oddly enough, most people only think about leaving it to their family, but there's something to be said about leaving something to the institutions that help shape you and help make you successful. So I believe in paying it forward. It's rewarding, I mean, when you have wealth, um, the more you spread it around, the more good it does, Uh, for example, all often, people say, what about my grandchildren? I said, nothing wrong with leaving a gift to your grandchildren, whatever, 50,000 when they're age 28 or 100,000, depending on your, comes right from you to them. The parents can't use the money for them because if the parents use the money for them, they'll never see the gift. So they're not allowed to use it. The money stays. If they're younger, it earns interest, and they get that gift from grandma or grandpa, or both of you, in this case, at that age. And I like those gifts because I believe they raise your grandchildren's self-esteem. What do I mean by that? Well, when you get a gift from your grandparents, it makes you feel good about yourself, that you have history, that you have background, that you're somebody from somewhere, that somebody thought about you and cared about you enough to leave you a nice chunk to help you get started in life. I know my father, who only died a couple of years ago, he left 100,000 to each of his grandchildren, and it was life changing for them. You know, they were in their late 20s. The others were older. The youngest were in their mid to late 20s, I should say, but made a tremendous difference in their lives. I mean, I can't tell you what a good thing that was and how highly I recommend that. Money that's spread out does more good than money that's concentrated. So if you have a few dollars and you leave it to your son and daughter, well, okay, but it wouldn't hurt to leave some to your grandchildren. It's not going to hurt your son and daughter. It's only going to help the grandchildren. So something to think about. I like to see them get that gift, the whole thing, at age 28 or age 30. Um, so giving back to our alma mater or to our place of worship, how much uh, did you get? How much did it enrich and enhance your life to have your place of worship? And how nice to remember them. Um, People think simply, okay, I have kids, it goes to my kids in equal shares. I just had a client in this morning who was a victim. This is his side. I didn't hear the other side, but his side was he was a victim of parental alienation. He split up with the mother, and the kids don't talk to him. She poisoned them. She had custody. All that. So um, he doesn't have a relationship with them. So should he leave his whole estate to them? Well, he doesn't feel very comfortable about that at the moment. But children sometimes don't need it. They're very, very well off, much better than their parents, or they're undeserving. They're estranged or um, uh, undeserving for any one of a number of reasons. Um, so these are the things we have to think about. What I told my client was, I have a saying. I say, our family are the people who love us and we love them, and the others are our relatives. You know, in other words, not necessarily the same thing. And I was very happy. He met a nice woman. He's been seeing her for 4 years. She has 4 kids. They accept him. He's starting to make a life, basically with a new family. Reason number three, showing you care. Well, let's see what that says. What's that about? Well, it's a stewardship. So, when you take time to plan your estate, you are sending a very strong signal to your heirs. This is the way it's done. This is what a person who takes care of their affairs does. It's stewardship. It's managing your family's assets and affairs. Um, you know, I just wrote an article. What's the difference between a financial advisor and an estate planner? Not everybody knows. Well, financial advisor deals with your money. They help it grow, and they plan for your retirement and they make sure you have enough income. Accountants, they do income tax returns. They know all the IRS rules and they prepare your returns. Estate planners are lawyers, and estate planners we don't spend all our day looking at numbers and finances and investments. We spend all our days talking to people and families about the family dynamic and how to leave things and who to leave it to and why. So don't get confused by getting your advice on who to leave it to or how to leave it from your financial advisor or from your CPA, because that's not their expertise or their training. Sure, they have an opinion, but it's not a professional opinion, it's a personal opinion. From an estate planning lawyer, you get a professional opinion. What have thousands of people done before me and why have they done it? That's really what you need to know. So you're showing you care by doing the estate plan. You're getting your affairs in order. You're doing it properly. You're helping them avoid probate. You're often keeping the assets in the bloodline, protecting the inheritance if they get divorced or sued, protecting the inheritance from the cost of long-term care, all of these things. That's what stewardship is. And it's, as I say, it sends a powerful message, and hopefully they'll copy what you did, and also take care of their affairs in a prudent way. And um, how people get money is often reflected in how they spend it. If they see you were careful with your money and how it got distributed, they're going to be careful in how they spend it. You might spill it out over a period of years, give them an income for life. There's all kinds of options, type of thing we talk about in the consultation. And in the consultation, we tell you what your options are based on our experience, what other people have done. And then you decide what suits you best. So you're going to be an example to them of how to do it the right way. Reason number four, we're going to save your heirs time and money. So first of all, we're going to save them taxes, but not too many of our listeners are over 7,160,000, which is the estate tax limit for the state of New York. If you're over 7,160,000, there's an estate tax to pay. It starts around 600,000. You can avoid the tax if you have a spouse. You can set up two trusts, double the exemption from 7 and change to 14 million and change. Not going to be a problem, right? So if you're single, we have plans to move the assets while you're living to get you under the limit. But number one, we're going to save the heirs estate taxes. We're also going to save them capital gains taxes by making sure it passes by inheritance, because anything passing by inheritance is capital gains tax free. We're going to save them legal fees. I had a client in today, um, she, well, she was 90 years old, her husband's 95, so the fees were high, but, for her, but then, she may not, she's 90 years old, she remembers a time when everything was much less expensive, but okay, it didn't bother me. But I told her, this is going to end up saving you money because your heirs don't have to go to court to settle. The house is in the trust. They can sell the house, divide the money. They won't even need a lawyer to do that. So the cost of setting up a trust is actually less expensive than not setting up a trust. Even though it costs money, it saves more than it costs. So we're going to save them legal fees. We're going to save them time. People underestimate the value of time. Time is life. That's what it is. Your time is your life. So do you want to be dealing with mom and dad's affairs for 2 years after they're gone, or 2 months? Um, well, 2 months helps a lot. It helps you get over the grieving process, um, and it doesn't just drag on and on. And time is very valuable. They get to move on with their lives. Life goes on, and we don't want to drag it out for a couple of years. So the time factor is often overlooked, but if I can settle an estate in weeks or months instead of years, I want to do that. You know, who wants to carry a house empty for a couple of years while the estate is in probate? Who wants to not have access to an investment account when the stock market is dropping and you can't move anything, you can't sell anything? All kinds of problems come from delays. So we avoid the expense and delay of a probate. Reason number 5, protect your assets from long-term care costs. The average cost of a nursing home today is about $20,000 a month. If you're over the limit, so the limits are 160,000 for a couple. If one of them gets sick, the other one is allowed to keep 160. If you're single, the limit is 32,000, which means if you're over these numbers, you're not eligible for Medicaid benefits to pay for your home care or facility care unless you spend down your assets until you get to the limits you're allowed. Well, we want to avoid that spend down. And we do that by setting up Medicaid Asset Protection Trust. I'm all for long-term care insurance, but I know a lot of people can't afford it, and a lot of people don't qualify for medical reasons. So you set up the Medicaid Asset Protection Trust, and it allows you to have your cake and eat it too. And here's what I mean. You may or may not know that the Medicaid Asset Protection Trust is an irrevocable trust. And people are afraid of the word irrevocable. Oh, I don't want that. No, oh no. Well, what they're not aware of is in New York, you can revoke an irrevocable trust. How's that? Well, it's irrevocable because you, mom and dad, or if you're single, mom or dad, the person who set up, you can't revoke it yourself. So law says, as far as you're concerned, that's an irrevocable trust. But New York has another rule on the books that says, if every person named in the irrevocable trust agrees in writing that they no longer want the trust, you may revoke it on the written consent of all the named parties, which is you and your kids. So you can always undo it. You also stay in charge. You name your son or daughter both as trustee. You reserve the right to change the trustee at any time. So you're a boss. You don't like how they're acting, you fire them. You also reserve the right to change who you leave it to. You have a falling out, you can change, you can take them out as beneficiary. So this Medicaid Asset Protection Trust, I say it allows you have the protection, you change your mind, you don't want it, you can undo it. So it's like having your cake and eat it too. Reason number 6, we want to protect the inheritance if the kids get divorced or sued. Oh, there's the broken ring. Oh my. The divorce rate's what? I think 43% so it says 50. Well, it got a little better, But when you're leaving hundreds of thousands or millions, it does make sense to protect it. So if they get divorced, that money is not available. It's in a trust set up by you. So you set up, let's say your daughter is married. We set up the married trust. We say, when I die, I leave everything to the married trust. The married trust says, Mary, you're in charge. You can do whatever you want, buy, sell, trade, spend. You can spend the whole thing, but it's protected if you get divorced. It's protected if you get sued. Everybody gets sued for something sooner or later. Uh, and uh, it protects it. Um, if you have a financial problem, large medical bills, you lose your job or your business, this is money that is protected. It's wonderful. You have the use and enjoyment of it that your heirs do. They can do whatever they want, but creditors and spouses can't come after it. So we use it to um, keep it protected from divorce, losses, and creditors, and it also keeps it in the bloodline. You know, almost every will says, "I leave it to my." Look at those cute kids with the flags. Must be July 4th. Um, um, most people's wills, almost every will from the beginning of time said, "To my children in equal shares per stirpes." Per stirpes means by the roots, which means if you leave it to your daughter or son and they die before you, their share goes to their children. Everybody says that. If my son or daughter dies before me, I want to their children. But the fact is, most children survive their parents. So if they die after you, does it go to their kids? No, it goes to their spouse. And can they get remarried and share your inheritance with a complete stranger? They often do. How many people here don't know somebody where his second wife got everything, the kids got nothing? Happens all the time. I can't tell you how often it's happened in my practice, um, but no more, not with our clients, because we make sure it stays in the blood. So you leave it to the trust, which says, Mary, you're in charge. You could do whatever you want. But when you die 50 years after me, whatever's left in that trust goes to your children, not your spouse and, wife number two. Now, you might be very fond of your son-in-law or daughter-in-law, not a problem. You can say, um, if my uh, son-in-law is still married to my daughter at the time of her death, and they're cohabitating. They still have to be living together because people could be married but living separate and apart. So if they're married to each other and cohabitating, leave half to my cute little grandsons there, keep the other half in trust for my son-in-law, give him the income for life, and on his death, give the second half to my grandkids. So the principal gets protected. He gets an income interest, but it doesn't go to his wife, his second wife when he dies. It goes back to the grandkids. So you can take care of the son-in-law or daughter-in-law. Now, you may not be ready to do that. Maybe the marriage is not that mature, but some of you know, we call you in for a free review every 3 years. So you might say, okay, well, we'll look at it in 3 years. We'll look at every 3 years. We'll decide when and if we want to do that. When the marriage is mature and you have a very well-established relationship. Reason 8 protects you if you become disabled. So a will only takes effect at death. A trust takes effect while you're living, which is why they call it a living trust. Okay, and the beauty of setting up a living trust is not just a plan for death, it's a plan for disability. And sometimes we like to say disability planning is more important than death planning because disability planning is for you. Death planning, by definition, is for somebody else. So if I become disabled, which eventually happens to half of all people, usually much later in life, I want my people in charge. I don't want the state to step in and appoint a legal guardian who I don't even know handling my affairs. And so we want to avoid the risk of guardianship proceedings. And the best way to do that is set up a trust because the courts have always ruled that if you have a trust, you don't need a guardian because you have a trustee. It takes the place of guardianship. And the nice thing about the trust is a judge can't cancel your trust. It's more powerful than the judge. So you're going to get the person you charge. You chose. It's ironclad. Why do we want to stay out of guardianship? Because once you get in, you can't get out. The key is to prevent yourself from getting in. Try to get back control from a legal guardian. Good luck with that. You may see. I don't know how long it took Britney Spears to get her freedom back. Decades. And it was very, very difficult. Multiple court proceedings. So we don't want to get in. An ounce of prevention worth a pound of cure when it comes to guardianship. Nobody wants to be fighting with a judge. The judge has all the powers. The golden rule. Who has the gold makes the rule. So we don't want to get into that situation. Trust avoids a guardianship. Reason 9 allows you to choose who will make medical decisions if you're unable to. Well, do you want your daughter or do you want the hospital to decide? So you choose your end of life wishes. Generally, you'll say, if I have no reasonable expectation of recovery from extreme disability, basically I have no quality of life, I don't want to be kept alive by life support, ventilators, feeding tubes, and the like. So you say what you want, and then you pick a person you trust to carry out your wishes. So first, there's a HIP authorization. So your son or daughter can get your medical records. They can talk to your doctors freely. Your doctors will communicate with them. Um, and it prevents the hospital making the decision because the hospital has their own agenda. They may want to keep you on life support for a long time if they're earning 30, 40,000 a day doing it. If you catch my drift. Reason 10 gives you peace of mind. Look at this very relaxed, happy looking couple. Um, you know, now, I often tell clients, estate planning, it's a peace of mind purchase because when clients walk out, they feel relieved. They know that no matter what happens, they have a plan to deal with it. It's all in writing. Their loved ones, the people they chose, have all the legal documents they need. And they have Ettinger Law Firm, very established, been here for 35 years, 12 offices, about 35,000 clients now. And that's secure. We have a succession plan. So, we're going to be here for your lifetimes and beyond. So that's good. Last week I had two clients come to me. The lawyer died, and that was the end of their plan. The lawyer was a solo practitioner. They can't even get the original documents. So that doesn't happen here. First of all, here, we give you the originals, so you don't have to come begging us. We just keep digital copies. And you and your heirs will have Ettinger Law Firm to rely on. Not only have we been doing estate planning for 35 years, but we also filed over 5,000 Medicaid applications. We can get you home care, facility care. Um, and, we don't charge for phone calls or emails. So anytime you have a question, once you've hired us and you paid the fee to do your estate plan, you have us on retainer for free. Anytime you have a question or concerns, call, email, it's no bother. We're happy to hear from you. Every 3 years, we call you in for a free review. So the plan will work when you need it, not when you wrote it decades earlier. Um, so that's us. Uh, if there's a law change, we'll tell you. I publish the Ettinger Elder Alert once a week, so you'll know about any law changes coming. And as I said, the free review comes every 3 years. That's a very secure plan. You're good now. You're with Ettinger. You're good. You don't have to worry about this. We worry about it for you. We call you in for the free review. We don't wait for the client to call. We'll never hear from you. Nobody's going to wake up 3 years from today and say, oh, I got to call Ettinger. So we take the responsibility. It's hard to find a firm uh, in any line of work, but in the law field, you can't find a firm that takes responsibility to call you for free review every 3 years. Nobody wants a responsibility. I'll tell you what the standard is in New York, as recommended by the bar. They say once you sign your estate plan, you should we should send you a letter saying, thank you very much for your patronage. This concludes our representation of you in this matter. So the bar tells us to do this because it closes the file and starts the statute of limitations running. So if we made a mistake, you can't sue us. Now, who's that good for? It's good for the lawyer, but what about the client? Well, this is the way lawyers are trained, which I don't agree with. They're more concerned with the 1 in 10,000 clients are going to sue them than the 9,999 that aren't going to sue them. So we do the opposite. At this point, we're beyond the experts, so-called experts. We say, thank you, but we don't consider it a transaction. It's not a transaction, at least in my view, it's a relationship. So we're going to keep you up to date. Law changes. We want you to call us or email us if you have a question. We're going to call you in for a free review every 3 years. We put the responsibility on our shoulders and we carry it with us and for you through the rest of your life. And I believe that's the way it should be done because it just makes for a much better plan. It's not a transaction. We call you in every 3 years because this way we know the plan will work and you need it, not when you wrote it decades earlier. And also, it's a better plan. Why is it a better plan? Because I'm only planning for the next 3 years. That's easy to see. If I have to plan for the rest of your life, I don't have a crystal ball. That's just too much time. So more effective to have a plan that gets looked at and reviewed every 3 years. We do it free. Why do we do it free? Because if we charge, nobody would come in. So we do it free, but work comes out of it. If you need to change the legal documents, there's fees. If you need Medicaid, obviously there's fees to do a Medicaid case. We get a lot of estate administration because the clients know us, their family knows us. So it's all good. It works for everybody. But you come in, we review everything. If you're okay, there's no fees. We were glad to see you. And we're building a relationship for later on when we're needed. There's a bonus reason. Look at that. Just for larger estates. So I don't know if anybody's over 7 million, but here you go, 7.5 million, you owe over 600,000 taxes. If you have a spouse, you set up 2 trusts, double it to over 14 million, and you could save 600 to 1 million in estate tax. Just a word to the wise. If you're over the limit, you have to do this before the first spouse dies. Okay. So let's talk about our unique planning process. It started with this talk. That's my new book, 2025 edition, Ettinger Law Firm's Guide to Protecting Your Future. So our process begins with a seminar. We offer no cost initial consultation. We're going to review your existing plan. If you have one, you bring in the documents. We tell you if there's issues, almost always there is, because it wasn't done by an elder law firm. We'll give you a free copy of my book and advise you which chapters apply to your situation. As you go home and read those chapters, we're going to tell you what we think you should do and how much it'll cost. That'll be verbal. And we'll ask you to come in for a second consultation to have your questions answered. So now you come in a couple of weeks later, have the second consultation. We answer any questions you have about what you read in the book. We draft the estate plan together with you. What I talked about earlier, who gets it, when do they get it, how do they get it, who's in charge of legal, medical, financial, etc. And then we give you a detailed written proposal for the fees quoted. So same fees we said first time, but now it's in writing. And then we say, what would you like to do? Fortunately, a lot of people will say, let's go ahead. And I believe we're the only law firm in the United States that doesn't take a retainer. And now every law, I did it for years because I was trained. The client wants to go ahead, you take a fee for 1/2 in the beginning and the balance at the end. Well, I thought about it, I finally analyzed and I realized the reason I was taught that way is because it's good for the lawyer. But when I analyzed it, I realized it's not good for the client. Because when you give the lawyer a check for half, what do you have? Nothing. In fact, you have less than nothing. You have a loss of control because you paid money and you have to hope they're going to perform and they're going to perform to your satisfaction. Doesn't always work out, but you already paid. So we don't do that. We say, on your say-so, we're going to go ahead. You come back a third time, we'll review all the documents. After everything is signed and you're satisfied, you pay us. And in fact, I say that you owe nothing to the law firm unless until you sign your check, your boss. And here's why we do that, because obviously this is the best thing for you, the client. Now, if we're here to serve you, and it's the best thing for you, it must be the best thing for us. That's how we think. So we've done this for more than 10 years, and we're very happy, and so are our clients. We only have happy clients, which is what we want. Never have unhappy clients because people only pay us, everything's done, and they're satisfied. So you come in, you have a final meeting, review and sign the documents. Credit cards today, we got to take the 3% because it's crazy, but you can pay it all at once, or most people now pay by check, or you could do 3 monthly installments if it's easier for you. Some people pay it out of their cash flow. So as I said earlier, we don't say goodbye. The New York Standard, we say thank you, welcome to the firm. We're going to keep you up to date of law changes and other matters with our Ettinger Elder alert because it comes by email. Pre-review every 3 years for changes in your health, assets, family, births, deaths, marriage, divorces. We don't charge for phone calls, emails, questions. It's no bother. And the point is, by using this program, your plan is never more than 3 years old, designed to work when you need it. Not when you signed it, I hope, quite a few decades earlier. Once a month, I give my seminar that I've been giving for over 30 years. It's a very good seminar, The 4 Advantages of Using Trust. You can register at trustlaw.com, and it'll be Wednesday, September 10th at 6:30 is the September one. There's one each month, as I said. And I'll talk about revocable trust, irrevocable trust, Medicaid trust, inheritance protection trust. It's pretty comprehensive. If you haven't seen it, I think you might want to register. Um, and even if you can't make it at that time, if you register, you get the recording, so you can watch it at your leisure. The advantages of technology today. And now I'm going to invite you at your leisure. You can schedule a no-cost consultation with one of our experienced elder estate planning attorneys. It can be with me if it's one of the offices I work in. Basically, the Huntington, I'm in Huntington, Rockville Center, Nassau, and once a week I go to either White Plains or Staten Island. So you can see me in any of those places, but you can also see in Melville and Islandia, my lovely wife and law partner, Suzanne, very experienced, capable lawyer. And all of our lawyers are trained the same. You could see any lawyer at the firm, and you're going to get the same consultation pretty much. So we prefer it in office. It's more valuable in the office. You get to, much better rapport, and you get people's facial expressions, and you can see who we are a little more. But if you can't make it, we will do it by Zoom or by phone. You just call the number and schedule it, or visit us at trustlaw.com. You can do it there. So now let's see if we have any questions. Okay. Okay, let's see, stop the share. And this will see if we have 6 questions. So let's answer those first. Hold on. Oop, oop. What did I do there? Okay. Okay, these. Okay, anonymous. My internet went off. Not sure whether you received my question. Can a trustee of an irrevocable trust of the house and financial accounts on their beneficiary file both the state tax return and final income tax return? Yes, your trustee can do that. There's not a problem with that. What is the threshold for state tax returns? In New York, 7,160,000. The federal is 15 million. Trump, that's the Trump tax law. Anonymous, are newspaper articles available on your website? Yes. May I be well, they're all supposed to be there. Email, if you want those articles, contact P. Brown, she handles it, Patty Brown, but it's pbrown@trustlaw.com, and she can give you all my columns for the last 3 years. Okay, let's see what else we have. Is your book downloadable from your website? Yes, you can download it from the website, or you can purchase it at Amazon, either one. Is it cost prohibitive to administer the estate plan by a law firm if there's no one to do it? No, we do it for a lot of people. I don't think it's cost prohibitive. It's 1% of the first million, 0.75%, anything over that. People don't generally have a problem with that. Somebody said, how long will the recording be available? That's, kind of above my pay grade. You can always ask P. Brown at trustlaw.com. She'll do that. And then I have a number of questions that people sent in. I'm just going to give their first name. Abby says, if you leave property heirs, will they be taxed on the inheritance? No, in New York, where there's no inheritance tax, they get up to 7.16 million tax-free. Marvin says, Marvin Y., can a step-grandchild be given the same rights as protection as a grandchild from my bloodline? Absolutely. Can that individual and their offspring be included with members of my bloodline? Absolutely. With the purse therapies? Absolutely, not a problem. Darlene F. says, if I put my house in a Medicaid trust and I buy another house and take a partial mortgage on it, can I sell the home in the Medicaid trust and use some of the proceeds to pay off the mortgage on the new home if I also put the new home in the trust? Yes, you can do it, Darlene, but we have to guide you through it, how to do it, because you have to be very careful not to break the Medicaid rules, but we know how to do it. It can be done. Anna C. says, if you have an irrevocable trust and the person you're leaving to your house owns school loans that are not being paid for, Could they take the house? Well, we can protect the house by leaving it in a inheritance protection trust, not available to lawsuits and creditors. So they wouldn't be able to come after that house for the student loans. Not a problem. Colleen V asks, how do you change beneficiaries on existing trust? We do that by an amendment, with the same formalities as the trust. It has to be witnessed and notarized. Um, Cheryl W. Protecting inherited money in case of divorce. Well, one way is to keep it separate, so to show that it's separate property and it's not subject to be divided. Anything you keep separate, any inheritance you keep separate doesn't get divided with your spouse on divorce. Technically, any appreciation of that money is marital assets, but the money itself, it was 50-50 on the appreciation, but the money itself you get back. Chitra B says, do I need a will and a trust? Yes. Well, with a trust, we always do a special will. It's called a pour-over will, P-O-U-R, that does two things. One, by law, the later will cancels the earlier will, but this pour-over will says, in case there's a loose end with no beneficiary, put in the trust after I'm gone because my wishes are written in the trust. Kristen H says, I want to create an irrevocable Medicaid trust for my daughter to protect my assets. What is the cost of this? Do I need her present at the first appointment? No, Kristen, she would not come in till the third appointment because you have the two no-cost consultations. She only has to come in to sign. These trusts, they run between, between 6,500 and 8,500, depending on circumstances, somewhere in there. But if you're single and you just need the trust, more like 6,500, plus the filing fees. If you want to keep it in the blood, you might want to set up an inheritance protection trust. It would cost you a little more. We can talk about that. Marie G says, what's the difference between a trust, a Medicaid trust, and a pooled Medicaid trust? Well, revocable trust, you're in charge. You could buy, sell, trade. You name it, somebody who takes over if you become disabled, a backup trustee. It avoids probate death, doesn't protect your assets from long-term care, all available for Medicaid. Medicaid Asset Protection Trust, somebody else is the trustee. You're the beneficiary. You have the exclusive use and enjoyment of the trust assets. You get all the income, but you can't take out principal because if you could get it, Medicaid can get it. There's a way to get your money out. You can make a gift of any amount tax-free to your children. They could spend it on you. All of this, everything I'm saying is in my book, which is in plain English. You can download it from the website or order the hard copy at amazon.com. Pooled Medicaid trust is only if you apply for Medicaid for home care, you set up a pooled trust, which allows you to protect your income. So what happens is, it's a little strange, but any expenses that you have, you could send to the pooled income trust. You send them the income to cover the expenses, and Medicaid that won't go after that income, which means anything you can expense out income-wise, you'll be able to keep, so you'll be able to afford to live in your own home. What is the downside? Louis and Gail B say, what is the downside of not having an asset protection trust? Well, if you don't have long-term care insurance, your assets are exposed. If you need home care, help with washing, dressing, showering, or you end up in a nursing facility, you can end up losing your home and life savings. So people generally, if they can't or won't get long-term care insurance, are looking at the Medicaid Asset Protection Trust. Here's Ken N. How can I set up a trust for a 13-year-old so he can take possession of the property and the pension plan? Well, you leave it in trust with somebody else, a trustee, until he reaches an age that you feel satisfied. You leave that 403B, just like a 401k or an IRA, to the trust. You can't put it in the trust, but you can leave it to the trust. And then you set the fee for the trustees of the trust. There's a statutory fee in New York. It's quite modest. You can use a statutory fee, or you can set your own fee. We can talk about that. Let's see. Mildred H says, we live in Florida. Can you put a house that still has a mortgage in a revocable trust? Absolutely. By law, you can put a house that has a mortgage in a revocable trust. In Florida, you also have the Lady Bird deed. You can put the beneficiaries right on the deed if you like. Colleen D is 80. She has no children. Most houses in a trust with us and beneficiaries a name. Yes, Colleen, we'll be happy to take care of that for you one day. Danielle B. My brother is disabled, and we've been reporting him as dependent on my parents' returns in the past. My father died in 23. My mother is due to file her taxes in October. Can my brother become dependent when she passes? That's a question, Daniela, for the accountant. I can't answer that. It's an accounting question. Diane J., is your firm experienced in representing gay and lesbian couples who are married and have no children? Absolutely. In fact, in my book, I wrote a chapter on planning for same-sex couples, and you can go onto my website, just scroll and download those pages and read about planning for same-sex couples. Stephen C. says, what about succession planning? My entire family traveled by air. If the plane went down, there would be only my two sisters and my wife's three brothers with their kids, etc., left. We would like the money to stay in the bloodline, but we can't manage from the grave. Well, listen, if your whole family gets wiped out, how much planning do you want to do for that? We generally would say, leave it to your brothers and sisters and equal shares. You don't have to get fancy with that. We're not going to set up trusts and all that. So we'll have to live or in this case, die with that. Mark G, do individual brokerage accounts need Medicaid protection? Yes. So qualified accounts, IRA, 401k, 403b, exempt from Medicaid. They don't go into trust. They're protected from Medicaid. They're protected from probate. They have a designated beneficiary. But your individual brokerage accounts have to go into the trust because otherwise they're exposed to the cost of care. Carol P., we don't have offices in Florida. Florida is a big place. So if you need a lawyer anywhere near Palm Beach Gardens, that's my buddy Joe Karp. It's carplaw.com with a K, carplaw.com. If you don't have, if you're not near that Palm Beach Gardens area, or was it Port St. Lucie or Boynton Beach? They have a couple of offices. That's Carplaw, KRP, carplaw.com. You can go to the website for the National Academy of Elder Law Attorneys, NAELA.org. National Academy Elder Law Attorneys, NAELA.org. And you can search for elder law attorneys by zip code. I tell people, look at their websites, see which ones, have good websites that you feel comfortable with. Go and meet two of them and decide which one you like better. Two is plenty, okay? Because you've already done the due diligence by studying their website. So looked at educated top trusted with 61, okay. Okay, what's your okay? Okay, so that just about does it. So let's see if anybody came up with a question since we've been doing this. There's usually a couple of stragglers there, yes. Which tab should I go to download the book? The fee you mentioned in administered the estate. Is it every year or total fee till it? Well, it depends, the trustee gets the fee every year that they're acting as trustee. The book, there's a picture of the book, you can click on it. If it's, if you're having trouble, contact P. Brown at trustlaw.com and she'll send you the book in a PDF, okay? And then finally, is it possible to get the link to yeah, there you go. P. Brown at trustlaw.com, she'll send you the link. You can print out the whole book. If you want like 300 pages on your printer, or get the hard copy at amazon.com. Okay, that looks like about it. Thank you so much for joining. I wish you all a very good afternoon. Hope to see you in the office very soon. Thanks for coming and have a nice rest of the summer. Thank you. Bye-bye.